This is The Professional Edge. My name is Sean Todd, tax attorney, CPA, and certified financial planner. Host here on The Professional Edge for north of 5 years. What we're talking about is the golden ticket. Well, there's golden tickets to planning, being retirement planning, tax planning, estate planning, when to elect Social Security, do we need to do a Roth conversion, and how much do we need to do a Roth conversion? So those are all items for consideration. So if you are worried about your estate plan, or that is one of your New Year's resolutions, the great place to start is going to our website. That is emcadvisors.com. And going on the right-hand side, there is a red sort of portfolio button which says Ultimate Estate Plan Guide. And that we send out to our listeners here on The Professional Edge that request that free of charge. We're even covering the high rate of postage. It went up just last week again. So we send that out to you, and it gets your thought processes started on what you need to consider in your estate plan. Meaning if you have minor children, who's going to be the guardian of those children? That's number one. Or if you're older, how are we going to make sure that our surviving spouse is all taken care of? And if we have that condo down in Florida or in Alabama on the Panhandle, then we want to make sure that we avoid ancillary probate. That is a probate estate in Florida, and then also a probate estate in Georgia or your domicile state. And when we have ancillary probate, that normally involves two attorneys, and therefore we all know that attorneys do not work for free. Me being a licensed attorney, I don't work for free, but there's a way to avoid that whole process, and that is through utilizing a revocable living trust. That's the golden ticket of estate planning. Now, a lot of attorneys, even the probate court judges in Georgia, say that probate's not a big thing. It's easy. Well, look at the probate fees and look at the court cost, time delays. That whole process can be avoided. It's as if we're driving a horse and buggy to destination A, or we have an automobile. Which one's going to be more efficient, quicker, and makes the most sense because things have changed from the 200-year probate court process? Well, let's utilize this new vehicle and avoid the probate court process. That's number one. Number two, there is no publication of your information, so if privacy is of concern to you, that would be another reason to instigate your plan with a revocable trust. And then number three, if you don't want this thing tied up 9 months to 2 years in the probate court, let's go ahead and do that too, because there is no probate delay in the distribution of the trust assets. Now, when we look at a trust, we have this for your life. It is called an inter vivos or a grantor trust. It is completely changeable, revocable, and you're 100% in control. But here's the downside. It is not a creditor-proof trust. That's when testamentary planning starts, and now the first spouse to pass away should actually park their assets in a trust for the surviving spouse, and those assets would be creditor-proof. Now, the surviving spouse is going to be the trustee and the beneficiary of these testamentary trust assets. So we're not keeping them away from the surviving spouse. We are just cloaking them in a legal format to keep the claims of creditors at bay. Now, with the estate, let's say it's $2 million when the surviving spouse passes away. Let's do not leave this outright to the surviving children in equal shares. In our scenario, let's have 2 kids, so they're, quote, potentially inheriting $1 million apiece. Let's say they're in their 30s or even in their 40s. It makes zero financial sense to leave these dollars out to them outright because now it is subject to the claims of the creditors of your children. And the largest potential creditor of your child is your ex-son or daughter-in-law. Think about that. Over half of all marriages are ending in divorce. Do not attempt a second marriage because that is an 80% fail rate. That's the numbers. I'm not making those up. You go to different bar conventions and the numbers are just there. 50+% of marriages are ending in divorce. So the largest potential creditor is going to be that ex-son or daughter-in-law. But if we do the estate plan correctly, then we can park these assets in a testamentary trust, allow the child to have access to those assets for health, education, maintenance, support, buy a house, buy a lake house, travel, do whatever they need. But if their marriage should unravel, then the ex-spouse is not going to have a claim to these assets. If that right there alone is of enough concern for you to make a call to 877-654-9798. That number again, 877-654-9798. And being a listener here on the Professional Edge, full disclosure, we changed phone systems at the end of 2022, and if you actually called that 877 number, you got that it was disconnected. Well, we've got it resolved thanks to some tenacity from our IT company, and now it is actually ringing in. So give that number a call, 877-654-9798. We talked about in the prior section of disinheriting your children on the IRA or your 401k. So if you have named them as the contingent beneficiary, spouse being the primary beneficiary, there is a potential that you will disinherit your children on the value of your retirement account. So again, coordinating your estate plan, we're going back to this asset protection. It is very important. Again, we're in a very litigious society. That's number one. But number two, when you track these and you want some certainty and you are able to protect those assets for your children from the claims of creditors, which include a potential ex-spouse. We're seeing marriages go to 30, 31 years, and then boom, all of a sudden it changes. Well, why have these subject to that potential claim? Give your kids the access to it, but secure it from the claims of that potential ex-spouse. It takes a little bit of effort up on the front side of your planning, but it only can benefit your children. It can't really hurt them. So why wouldn't you put that in place? So if you have your last will and testament and you say, hey, I got my estate plan done, and your plan of distribution is all to spouse if they survive me, but if my spouse doesn't survive, it goes outright to my kids. Well, lo and behold, it's theirs now. It is not creditor proof. It is subject to the claims of any and all creditors, including the claims of an ex-spouse. Yes, in Georgia, the court is going to rule on a equitable distribution, not equal. Understand that. Equitable means that the person in the black robe is going to decide how they feel it is going to be divided. Let's not leave that into chance for the person in the black robe. Therefore, what we would do is actually segregate these assets, put them in a testamentary trust. If that relationship falls apart by no fault of your child, then they're fine. These assets are going to be safe and secure from the claims of that potential ex-spouse in this divorce. So if you have left your items directly to your surviving spouse, if there is none, to your kids, let's get the golden ticket and creditor proof these assets. Give our office a call at 877-654-9798. That number again, 877-654-9798. We can meet down here at the Cunningham Center or in Atlanta if you want to brave your driving skills, or in the advent of Zoom. It's incredible. The vast number of clients we have outside of the state of Georgia, and I have physically not met them, but other than a virtual conversation that we have, and we accomplish their objectives. It's pretty incredible. So geography is not a limitation. And if you're hearing some good things on this podcast or this radio show, which is also broken out in a podcast called The Professional Edge, send this along to the person that you think can also help. It's information, but information is worthless unless you take action on that information. And you may be listening and you say, wow, that is a great idea. You know what, honey, my last will and testament, I know, just gives everything outright to you. And then it goes, if you're not alive, to the kids. Whoa, I'm not sure about my daughter's relationship with my son-in-law. So why don't we put this in trust for her to protect it just in case. There's no guarantee that this relationship is going to last. So if it does last, no harm, no foul. But if it doesn't last, wow, what a plan that you put in place for your kids to protect those assets from that divorce proceeding. So again, where do you start? Well, one place to start is visit our website at emcadvisors.com. That is Echo Mary Charlie Advisors.com. And on the right-hand side, it's called the Ultimate Estate Plan Guide. Go ahead and click that. We'll send it out to you. And that gets you thinking about A, asset protection. Number two, avoiding probate with the use of what we call the ultimate estate plan, and that is the use of a revocable trust that is actually funded. Things are retitled into that trust, and we take care of that for our clients. And the incentive to move forward, then we switch you over to one last website, and that is emcthebundle.com. That is Echo Mary Charlie thebundle.com. And that's where we put these golden tickets together that we've talked about during this session. And we put in your estate plan, fully integrated with your other assets, meaning who is your beneficiary designation and contingent beneficiary designation on your qualified accounts. So therefore, again, you avoid the chance of disinheriting your children on that account. And then we coordinate and say, hey, when they receive their monies, we want that money to also be coordinated so it's protected from their potential creditors. We want them to still have access, which we design in the estate planning document. There is no restriction on the amount that they can take, what they can use it for. But if something should happen, their relationship falls apart, or if they are sued via a motorcycle accident that they caused because they were texting on the telephone, well, these assets are also protected in that lawsuit again. So again, that website is emcthebundle.com. That is Echo Mary Charlie thebundle.com. So if you're listening to the radio show Professional Edge or our podcast Professional Edge, which is on Google or even on Apple, then send this along and say, hey, Jim, you might want to take a listen to this because I know you were talking about estate planning and you're not so sure, and you shared some comments about your son's relationship with his wife and how she is a spendthrift and not sure how that's going to play out. Well, you know what? There's no downside risk to putting this in place. It can only help your child save these assets. It can't hurt them. So again, that decision should be made. That's a golden ticket. Get your estate plan in force and in place to secure these inheritable assets for your children from their creditors. And also then the golden ticket with regard to your qualified account, being your IRA or your 401k, is to make sure that you guarantee that your children are not going to be disinherited. These are great planning opportunities, and they are not going to happen by themselves. So again, you got to take action, and that is one thing I pose to our listeners here on the Professional Edge. Pull out your estate planning document, read through it. If you don't have one, then you need to start the process to get one. So again, the incentive, get started doing something moving forward, so that way at the end of the first half of 2023, you can say, look at everything we've accomplished, and kudos to us when you go to the beach or wherever your vacation travels will take you. You can celebrate your win. Yes, it's you can't share it or display your keen planning. We don't put billboards on the side of our car saying, hey, my estate plan's done, but you internally know that your estate plan is done. So again, I appreciate you listening here on the Professional Edge. My name's Sean Todd, tax attorney, CPA, and certified financial planner. If what you've heard is of interest to you and you want to coordinate a personal consultation, give our office a call at 877-654-9798. That number again, 877-654-9798. Thanks for listening to the Professional Edge. My name's Sean Todd, tax attorney, CPA.
We've all thought about it. Everyone listening will need one. Not having one can cause untold heartache, family conflict escalating to the point of a lawsuit. One simple thing that avoids all that: an effective estate plan. As a practicing tax attorney, Sean Todd with Estate Management Counselors has completed over 1,000 estate plans during his 15 years of professional practice. He can help you implement an effective estate plan, coordinate your financial accounts, and make sure you have named the proper beneficiaries to maximize your tax savings. Call 877-654-9798 today and let tax attorney Sean Todd help you implement an effective estate plan. Call 877-654-9798 today. As a tax attorney CPA for over 15 years, Sean Todd has implemented over 1,000 individual estate plans. He has recently authored an especially helpful guide, How to Unlock the Ultimate Estate Plan. This guide has helped many individuals to understand the benefits of an estate plan and how to avoid unintended disasters. Sean has made every attempt to write this in plain English. To receive this valuable guide, How to Unlock the Ultimate Estate Plan, call 1-877-654-9798 and request your complimentary copy today, or by emailing your request to info@emcadvisors.net.
Is your 401k beneficiary correct? Having the incorrect beneficiary could cost you thousands in unnecessary taxes, and even worse, disinheriting your own kids. Hi, this is Sean Todd, tax attorney, CPA, host of the Professional Edge radio show, aired Sunday at 9 a.m. Not sure if you have the correct 401k beneficiary? Visit emcthebundle.com. That is emcthebundle.com. Again, emcthebundle.com.